I think I see you there, man, but we
Yes.
can't
hear me.
I got you now. And I forgot to ask counsel.
Hear me?
Yes, I can hear you. Do you have any witnesses or evidence?
Hear me?
I can hear you. Can you hear me?
Okay.
But you're also having very choppy signal, ma'am. And so I don't know if you need to go to a better connection. I mean, a location, but it's difficult hearing you, as well as you're kind of grainy as well. So, counsel, do you have any evidence or any witnesses?
Yes, Your Honor. Well, we have, let me say this, Your Honor, we don't know what we have to have evidence for. We were not given the information for the application. So we just got a notice that had the hearing date and the allegations to some offense. And we submitted to the court some information of evidence that we did file, but we really don't know truly what these allegations are about. So I don't know if you want us, I'll wait till the hearing starts for any objections, because we would argue that in the interest of substantial justice and fair play, that we don't know what really we're here defending. So,
I got that. I try to make sure, and that should have a copy of the application to some degree, or it should have been also included with that notice, so you knew what was going on, or at least have some knowledge of the event and date that's normally emailed or mailed rather with the notice. But nonetheless, I can obviously advise you of that. But what I will tell you, and because both parties are here, and I'm going to tell this to the other participants as well. Anyone here, now that I have called the calendar, I'm going to give an opportunity for those folks who have both parties here. So that would be position 7, Desmond Way and Tanesia Thomas-Way, as well as those parties in the Maddox matters that have both parties here. That if you are interested in going into a breakout room and discussing the matter in a civil way to see if you can resolve it without actually coming before me and presenting any evidence, I will afford you that opportunity. In many situations, folks come to a resolution, but if they do not, I want to let you know that the court is ready and willing to hear any evidence associated with the matter. But I first want to give those folks the opportunity because, and let me say this, before I do that, and before anyone gives me an announcement, let me finish my announcements and then I will discuss how I will proceed with the cases. All right. But let me first tell folks the reason why I may suggest that folks have a conversation in a breakout room. As I mentioned earlier, my job is to determine whether or not there is probable cause. But ultimately, if I decide that there is probable cause, I can issue an arrest warrant against someone. But that in some ways, and well, in special conditions, but I first have to issue an arrest warrant. I can't do anything unless I say somebody goes to jail. That's it. So I just want you to be aware that if you are looking for some sort of other recourse, right, it's not going to happen other than someone going to jail. Let me also tell you that if I do order someone or order a arrest warrant for a particular person, I generally give that person between 7 to 10 days to turn themselves in. Why? One, I try to give folks an opportunity so they don't lose a job. As I said before, this is not a full follow through or trial. We're not making a determination of whether or not someone has committed a crime. And in many situations, these allegations are about an occurrence that happened months prior, right? Or at least a month or weeks prior. And sometimes the urgency for an immediate arrest does not rest there or is not there. However, if it's there, I can do that. But in most situations, it's not. Okay. And so a person is going to have an opportunity to turn themselves in. Finally, when that person turns themselves in, I'm going to let you know that I will be issuing what is called a UJR, an unsecured judicial release. That means that even though I issue an arrest warrant, that individual that has to turn themselves in is not required to put up any monetary bond to be released. Now, the caveat to that is if I find that the facts or the crime that was alleged may justify certain special conditions, I might do that. Commonly in these type of cases, I usually will issue a stay away. And that just means that the person who is considered now from respondent to defendant, because I didn't issue an arrest warrant, has to stay away, no communication, no contact with the applicant / victim at all. That means no online. That means no phone calls. That means no riding up to their job. That means don't buy me flowers, right? Don't send a post. I don't want to see it, because if you do it, you might be putting yourself in position to be arrested again, and even arrested for a felony. All right. So just take that in mind as well. Okay. Keep that in mind as well. All right. But with all of that being said, I want you to understand too that I'm listening to see if there's a particular crime even committed by the applicant. That's my job. Oftentimes people come here and they say, nothing was done wrong, I'm the victim. And it come find out, you are the one who called the fight. You're the one who pulled the gun. I hear it all the time. So if that's the case, I can as well issue an arrest warrant against the applicant. The applicant is not free from the search of the law. Okay. So just keep those things in mind as we proceed. But with that all being said, those cases, those three cases that have both parties here, I'm first going to go down the line. Miss Maddox, are you interested at all in having a conversation with the respondents to determine whether or not you guys can resolve these matters without the court?
No, so Your Honor, we've talked. It's not working.
No worries. I will review. Finally, position 7, counsel and Miss Thomas-Way. Are you guys interested in as well? Again, Miss Way, he's got counsel, so I'm not so sure that you would have to speak to Mr. Way. I only assume you guys are married because you have last names that are the same. I could be making a wrong assumption. But nonetheless, if you are interested in seeing about resolving this matter privately, you can do so. However, in the event that you want to proceed on, that is totally your prerogative. So I will first ask Miss Way, are you interested in having a conversation with counsel?
No, I'll proceed on.
Okay. I will tell you though, before we proceed on, you're going to need to fix the connection, because we're not going to be able to proceed well if your connection it's still bad. For us to have a good hearing, you still operating on 3G. All right. I need you to update. Okay. So if you can work on that, we'll go there. So while I wait on that, let me first address the notice for those cases where we don't have anybody as a respondent present. And those cases would first be Ms. Silas, Alyanza Silas. And I believe, ma'am, that's the only case, because the other matters either were dismissed for want of prosecution and or one of the parties or a case is being reset. So bear with me. I'm going to pull up that information. While I do that, can I get you under oath? Because I want to just search this. So can I get you under oath? Because I'm going to ask you some questions. You swear or affirm to tell the truth, the whole truth, under penalty and perjury of the law?
Yes.
Excellent. So I understand that there is an allegation of something that happened back on May 21st, 2023. Or that was when the police report was made. Yes. And this is when the alleged action was to occur.
Correct.
And the allegation when it was $1,500 removed?
Yes.
Okay.
Now, I'm not sure about the address, but I know everything else is correct.
That is the main thing that is of concern. So that's what the court is concerned about. I understand that this was made back in May. It is now August. Now, I will tell everybody, we've had a huge increase of people being evicted lately. And so I'm very cautious to say whether or not someone lives at a place if they were lived there 3 months ago. Because in Georgia, you could be there 3 months ago and be in a different place now, okay? In shorter time than that. So I'm just concerned about making sure that folks have the appropriate address.
Right.
Okay, bear with me. You've got him at this, you know that he lives at this Thaxton Drive, other than the police report.
This was the address on his ID, so I just went off that one.
Okay, and beyond that, do you have any other information that he lives there?
Nope.
When is the last time that you spoke with this person? Or had
the last time I spoke with him, I want to say June 3rd of 2023.
And were you aware of where his residence was at that time?
No.
Have you ever been to his residence?
No.
And I'm looking at the police report, and again, I'm not into taking any particular evidence on the case yet, but I understand in the report you guys may have had a relationship. Was that for an extended period? How long?
It wasn't long. It was about a month or two.
Okay. And in that time, you'd never been to his home?
No, he would just come to my house.
All right. You haven't heard from him since June. It's August. This was done in May.
No, he actually blocked me, so I haven't contacted him.
Okay, you haven't had any contact with him in some time. I thought you said June was the last time you had some contact with him.
Yeah, that was the last time. He blocked me after that.
Oh, he blocked you after the June conversation. Okay. this is what I'm going to do. I don't know, and you have no other means of confirming whether or not this address, but this was the address on his ID is for what you're telling me. And so you understand the court always finds that IDs are interesting because it is their responsibility to update their ID. But at the same time, more often than not, people don't live where their ID says, right?
Right.
But hold tight. I'm going to do some more review and then I will get to you shortly. Counsel, Ms. Way does not necessarily want to talk. So this is how we're going to proceed with these cases. First, I'm going to do the case of Ms. Way. I know you guys have that here. Then I will join the case, Ms. Maddox, because essentially it appears that these matters occurred from the same occurrence and have just two different parties. And then I will address those matters. Those probably be the bulk of our time. And then Ms. Silas, this is what I'm going to give you an opportunity to do. I'm going to give you a choice. I'm going to put you on the back end, right? Because I have folks here with witnesses and evidence, and it's just you, respectfully, and you don't have any witnesses.
Okay.
So I'm going to give you either an opportunity to have the matter reset, and this is going to be one of the things that I'd have you do. See if you can confirm with the officer if there is a new address for that young man. If there isn't, fine. But if otherwise, in that period, I just would have you continue to the next calendar, okay? To one, give you the opportunity to look that up, but two, so you don't have to wait on this long calendar and very well may not be heard because we generally like to conclude at 9:00.
Okay.
So it's up to you. You can wait, and if we have time, I will get to you. But that may not be until towards the end. And if it's after 9, then we very well would have the matter continue. So I'm just saying, I can't say for a fact because I don't know all the evidence that's coming out. I just want to give you that option and be straight up with you so you don't sit and be, and feel like we're just ignoring.
Yeah, I definitely understand. I'll do that.
Okay, so clerk, can we get her a definitive reset date?
When you were making your earlier announcement for Ms. Way, the issue of evidence, I don't think came up. She was correcting her phone. So I just need to know if that is.
Sure, that's correct. And I understand you guys are now starting, and I'm going to tell you exactly how we get it. Ms. Way, did you email any evidence?
Yes.
Okay. Clerk, is it possible that we can, Counsel Roll, can you put your email down in the chat box? And then we're going to, send you some of the evidence that Ms. Way has already submitted. But again, any evidence that I will consider, I will be posting. So you don't have to worry about it. Something that I won't be sharing with you guys. All right. So this is how we're going to proceed. Ms. Maddox, Ms. Campbell, as well as Mr. Price, I want you to pay attention. I'm going to get that date for you soon, Ms. Silas, so hold tight. This is how we're going to proceed. First and foremost, if you have witnesses, we're going to sequester those witnesses. What that means is those folks who are not actual parties to the case, they're going to be placed in breakout rooms. All right. So they don't necessarily, even though it's live stream, get hurt, try to make their evidence essentially with whatever has been testified to. And then they'll come in and then we'll get their evidence if need be. So as I said before, this is not a trial. This is effectively a probable cause hearing. But in this hearing, the goal is to see whether or not there's probable cause, not to go through all the evidence. And so what that means is if I already have sufficient information from one witness, I don't need to hear it from 4 or 5. And that's respectfully because that takes the court's time and may not add anything additional of any significant value to the probable cause viewer consideration. In addition to, I might limit someone's testimony, not because I'm trying to get them not to say anything particular, because the testimony I already made sufficient statements to support whatever the probable cause may be. Okay. And in addition to, this is a shortened, not a truncated matter. This is shortened. So we're not going to be here for 3-4+ hours on one matter. That's not how it goes. And believe me, when I hear most of my cases from the officers, it don't take that long either. All right. In addition to, there is going to be an order in the way in which we receive this evidence. First and foremost, I'm going to get everybody under oath. And then after I get everybody under oath, I'm going to give an opportunity for folks to do an opening statement. Now, this is maybe considered harder or easier if you do not have representation, but this is how it generally will go. I will give the applicant 3 to 4 minutes to give us a brief background regarding the specific allegations in which I'm alleged or which were alleged. And that's really important because oftentimes people can get on a tangent and lose focus about why we're here. We're here about an alleged crime, not every single potential crime that this person has potentially committed against you. And so I'm going to be telling you the date and time of the particular issue or alleged crime so you can talk about that. And then I will give the respondent an opportunity to present either background about what's going on in an opening that they have in relation to that particular alleged crime as well. And then I will allow folks to introduce evidence. I will first start with the applicant. And I'll allow the applicant either one to introduce any witness testimony or any evidence or physical evidence that they've emailed to the court. I will generally, in most situations, share my screen and introduce that evidence and show it to folks. Okay, I will publish it. And then I will then allow any individual to contest it if they want to or ask questions about it. And then from there, after the conclusion of any witness testimony, I will allow the respondent to cross-examine them. And I'll make sure that folks understand the difference between cross-examination and direct examination. And then from there, I'm going to let the respondent have their opportunity to present any evidence, any witnesses, and any emailed evidence. And then I'm going to give the applicant an opportunity to cross-examine the respondent, right? And then we'll go from there as well. And then at the conclusion of those matters, I will give folks about 3 minutes to give a closing about whether or not why they believe an arrest warrant should be issued or should not be issued. All right. So what I'm going to do first, folks, I'm going to state specifically what the allegation is, so everybody is acclimated about why we're here, counsel. And then from there, I'm going to give Ms. Way an opportunity to make an opening statement regarding that issue. All right. So hold tight. So we are here regarding the allegation of a false report of a crime that allegedly occurred on August 1st, 2022. So this is more than a year ago, folks. All right. And I told you sometimes that does happen. But nonetheless, the allegation is specifically apparently it's apparently a repeated alleged crime that occurred over a year ago, over a particular amount of time. But the allegation that it had specifically on August 1st, 2022 in DeKalb County. And those are the specifics of false report of a crime. That is why we're here. All right, counsel. You indicated that you did not have any witnesses. So the time right now is essentially 7 o'clock. So I'm going to give you till about 7:04 to tell us specifically the background regarding this allegation of false report of a crime that happened on August 1st, 2020. Floor is yours.
Actually, it happened. You hear me?
Mm-hmm.
Actually, it happened. It happened August. I want to say August 4th. But I had got me and him have a 3-year consent temporary order, and I got arrested for violating the family order on August 4th, and no, it might have been August 5th. But I tried to go get my kids from school, and he used the 12-month order to withdraw my kids from school, so I couldn't get them from school. And he also been having the police come to my house as well, and he have defects coming to the house.
Okay.
And I talked to the detective, I think it was May 3rd, but she called me May 1st, May 2nd, I can't remember because I know I had to go to court for the violation. And she wanted to talk to me and say that it was that she wanted to know why I had so many cases against me from one person. And I only knew of one case. And that's when he's supposed to have the police come to the house for a wellness check. But the other stuff I didn't know anything about. Because he said that I guess in January or something, I was supposed to have been texting him. And I also had detected that information as well because that's the same day that I had activated another phone. And it was my daughter's phone, so I didn't text him.
Okay.
So it's like since with the consent order, he has no visitation or custody, and it's like ever since then he's just been having the police come defects coming to the house.
Okay. All right. I'm gonna is that all that you have to say for your initial opening? Is the whole particular? And I'm not saying you need to say anything more. I just want to make sure if you're done or not.
Yes, I'm done.
Okay. All right. Counsel, do you any opening regarding these allegations?
Yes, Your Honor. On or about, and this is from what I know because I don't have any of her evidence yet. On or about August 4th, the petitioner was arrested for violating a family violence order. She subsequently went to court, case was open, and she pled guilty to said violation and was adjudicated. I'm sorry, Your Honor, first on August 29th, 2022, after this violation after she was arrested. This court had a hearing where the court deemed that the violation was valid, and it issued a warrant for her arrest. Subsequently, the petitioner pled guilty to the allegations. And so we believe, one, the doctrine of, I guess it wouldn't be for my client, but for her, you know, we believe that this case should be dismissed because she pleaded guilty to the very thing that she's saying is false. And so that there is no facts to support any claim, so a dismissal is appropriate and before a trial even occurs, Your Honor, because we do have evidence, and we submitted the evidence to the court in the certified court document that, as she just testified in her opening statement, that on May 2nd, 2023, she pled guilty to the violation that she's now alleging is false. And that was a negotiated plea.
Okay, all right. And you submitted those various evidence, so we'll get to that, and I'll review that shortly. So what we want to do, because obviously she's making this allegation, is on the report it says the first, she's now saying it's the 4th of 2022. And I just want to confirm here that there was maybe an allegation, or there was a plea put in for either similar, a similar or the same event after the fact. But it appears that she's saying that there are multiple events of false reporting of a crime. So we'll just hear out what she has to say to see whether or not it meets, and as she made the application, and then we'll go from there. Obviously, if it needs to be dismissed as a matter of law, that's what we'll find, and that's what the court will do. As I said before, this is not a trial; it's probable cause hearing. So if it isn't there, then it won't be granted, and that'll be it. All right. If it is, then we'll go from there. So, Ms. Way, Thomas-Way, please tell me, since you don't have any witnesses, what particular evidence would you like the court to review for your consideration?
I uploaded the information already.
Okay. Give me 1 second for the court to try to see if we can share our screen on the matter to do this.
Your Honor, if the evidence is to these two documents, I have it now in front of me. So
Okay. I want to get this figured out, though. I do know we may not have counsel on the next case, so I want to make sure I can get folks to see this here.
understandable.
1 second. All right. Well, what I'm reviewing, and I'm going to see if I can get an opportunity or maybe do another device to be able to share my screen. So what I'm reviewing, ma'am, this appears to be it's in the Superior Court of DeKalb County. You also, it doesn't state specifically, but you're detailing your strained relationship. And then you provide an email. You have an email here apparently from Desmond Way to the school, indicating that apparently indicating that she's being removed from a school because of the custody. Apparently, there's various other emails sent to the school regarding switching the child out. And then there's an incident report that was also submitted from an incident that happened in November. So this is after the August 1st date that we're initially talking about. Much of it is blacked out, but it indicates that there was an event that occurred on the 28th of November. Apparently someone making allegations that someone should commit a violent act against the other person, or against Mr. Way. Then there was another incident report that occurred on January of 2023. Apparently allegation of him texting or Miss Way texting. And then there's a withdrawal form of the student. Ms. Way, are those the documents that you submitted to the court?
Yes, and also it's where I did the modification to when he withdrew when he took it.
Yep, I'm looking at that now, and so as well, you've also submitted a modification, motion for modification.
Yes, that was the only way. Good.
And apparently you submitted that motion. Was that motion granted?
Yes, it was. That's why that's when we agreed to the 3-year consent. Or was it? No, he was ordered to give me the kids back. If not, he was going to get arrested for interfering with custody.
Okay. Anything else?
No.
Okay. Any other witness testimony that you'd like, or any other evidence you'd like the court to review?
No.
Okay. Then I'm going to give an opportunity, because counsel has also seen this information. I'm going to give him an opportunity to do what is we call cross-examination, because you've essentially afforded yourself to this particular complaint or application and have now made testimony. He's going to be afforded the opportunity to cross-examine you. And so you're going to take yourself off mute. He's going to ask you some questions, and you're directed to answer them, okay?
Okay.
All right, counsel.
Your Honor, before we go to the Q&A, I just want to object to any notion that the motion was granted. There is nothing in the record or evidence to show such. It is a motion, an unstamped motion to the court, obviously signed by her 10 days after the date of these allegations, but nothing has shown that the court has acted upon that said motion. And again, it's unstamped, and there's no evidence of such, of anything dealing with the court's response to the motion.
Okay.
So, Ms. Way,
Yes.
on August 1st, 2022, which agency did Mr. Way report a crime to?
Which agency?
Yes, on October 1st, I'm sorry, I keep saying that. On August 1st, 2022, which agency did Mr. Way report a crime to?
It had to be the DeKalb County Police. I don't know because I don't know what's all in reports.
All right, so you
I only
don't,
know two reports. And the ones that I seen just online, and they say that it said that one, it's a whole bunch of them. It's like 5 or 6 of them, so I'm not sure.
so isn't it true you have no evidence that he reported a crime on October 1st, 2022?
No, it's sent to you. The reports are there.
Is
I
it,
uploaded all the reports.
do you have any evidence that he reported a crime about you on August 1st, 2022?
No, besides the police report, no.
Do you have any evidence of that police report today?
I submitted already.
All
And
right.
I think it's whatever the police report, because it's like 5 or 6 of them. It's like, I don't know.
All right, specifically, what crime did he allege that you committed on August 1st, 2022?
I don't quite sure remember which one it is. It could be that I attacked him. It could be that I was calling him from my daughter's phone. It could be that I was threatening him or somebody was threatening him. I'm not sure which one it is because all the police say something different. All the police reports say something different, so I'm not sure.
So are you saying that there are multiple police reports that
Yes.
on August 1st, 2022?
No, there's a different police report. I'm not sure on which date is what.
All right, can you point to the court the specific police report that you allege that he made on August 1st, 2022
Point to him where?
in your evidence?
I don't have it on my screen.
All right, you submitted the evidence to the court, so you have the original documents, correct?
Correct, but it's not. Hold on. So how do I supposed to put it up on the screen share? Because I'm new to this. I don't know nothing about sharing no screen.
Ms. Way, unfortunately, you won't be able to share your screen. If there is something that you need to submit, in addition to what you submitted the first time, you can send it into that email address that I put in the chat, and I'll get it to the judge as well as the attorney so that the judge will be able to share his screen.
That's right, Mr. Way. I can share I think I've had the device now. Clerk, on my second device, if you can give me the authority, I can share screen. But if it's a document that you've already submitted, those documents I don't believe are what you are currently referring to. And so, as I mentioned before, if you needed to send additional documents, you may have wanted to do that beforehand.
Because I'm not sure. I don't think it's a police report for August 1st. I think it's for something else. I'm not sure. I'm not sure on the dates of the police reports because there's a whole bunch of us. So I'm not sure exactly which one is which and the dates on them.
Your Honor, based upon the testimony, I ask for the court to dismiss this case because she's provided no evidence and cannot recall any evidence for the date that she's applied for the petition of a false police report. We ask for a motion to direct the verdict.
I hear you. I wouldn't necessarily say it's a directed verdict because it's not necessarily that case. But obviously this is a liberal, considering that this is a probable cause hearing. So I just want to confirm, Ms. Way, the alleged incident that you're saying, are any of the reports that you submitted to the court making a note of that? Do you have any specific crime that you're saying? I know counsel just asked. I just want to make sure that maybe we're confused.
Not for August 1st, no, because the incident is after August 1st.
Okay.
It's for the time because when I enrolled the kids in school, it's all started then. So all the incidents are after that.
So you're trying to say it started August 1st? Is that what you're trying to say?
No, I didn't put August 1st on it. That the incident started.
It did. It does say August 1st on my records.
Sorry, I need to put August 4th when everything started. When the
Okay,
day that I got arrested.
So even if that's the case, I'm sorry, counsel, I just want to make sure she understands.
It's okay,
Even if
Your
that's the case, is there a particular report that you're alleging that came from that date, and a particular allegation that you're alluding to that supports the purpose of us even being here this evening? What crime?
The crime that is the one for when he took the kids from out of school. I did that report. Then a couple of days later, the police came, but they didn't give a report on that. And then I think it was, I don't have the dates in front of me for the police report.
So and that can be problematic, but I just want to make sure I understand. Are you here because of the alleged report of a crime from August 1st or 4th regarding you taking the kids out of school? Is that what you're saying? Because I just want to make sure, because if we can't ascertain, we can't proceed.
That is because he, okay.
So continue.
Okay, so go ahead. I can hear you. What you say? No, I can hear you.
I know you can't hear me because your connection is not that great. Counsel, hold on. I'm just going to ask a couple of questions. Ms. Way, I'm going to tell you what your report, what your application says, okay? Just so we're all on the same page. All right. Your application says specifically that Desmond has been making and filing ongoing false allegation cases against me. So this is what it says, counsel. Desmond have had the police and DFACs come out to my residence repeatedly. And so on the application, it does not give a specific date. It just says August 2022. But however, at the top, it does indicate, though, and I guess because they had no specific date, they said August 1st as a start date. So you don't have a specific crime. You're saying a whole bunch of crimes are false.
Correct.
Okay. But for us to be able to proceed, you have to be able to clearly tell us what ones, so that the respondent can appropriately respond. Is there 5 of them? Is there 1 of them?
It's
what
5
is
because in the report it says 5. I'm gonna have to pull it up and actually read the police report. That's why I say I don't have it on the screen.
And you don't have that police report. Now, the police report I have, and just so counsel, just so you're aware, there is a police report. All right, I am going to share my screen. This may help. Hold on, counsel. This may give some insight because this was on the application. This should have been mailed to you. Hold on. All right, is this the report that you're referring to, ma'am?
Yes.
All right. Counsel, are you seeing this report?
I see the report, Your Honor, but this is in May 2023.
Well, the report is in 2023, but I think she's trying to allege that she made the report in May for the incidents that happened in 2022 and 2020, because obviously by the case numbers there, 2022 and 2021 and then I guess 1 in 2023.
Yeah, but again, Your Honor, are we talking about the report she made, or we're talking about the report Mr. Way made? This is a report she has made.
So just so I'm trying to be clear, she trying to put this together here. She's saying that since August of 2022, I guess these are the combined false crimes that cases that she's filed against her, which she's all culminated and brought to one report in May of 2023. I guess that this, if not, doesn't do a chronology or a chronicle of the events, but states what those are. Now, Ms. Ms. Way, the issue that we have is that I don't even know what those allegations are in those particular case numbers.
It's at the top. Is the case is above it. The police reports are above it.
I only have one police report, which is
Must be in the other document because I submitted.
That's all the documents that we got.
It was.
But if you submitted the documents, you should have them as well. So you should be able to tell.
I have them. Oh, hold on, let me see if I can pull it up.
Now, ma'am, it's 7:22.
No, I'm saying they in the email. They in the report. They in the email and report is in that one, as well as the modification is in the email by itself.
I know. I saw those. None of those had police reports.
Oh my gosh.
So, counsel, I guess what we're trying to find out, Ms. Way, if you don't have any information specific to which crime was false, then that's the part that we're going to have a difficulty proceeding with. Are you saying all these are false? But we don't. That's the thing, Ms. Way.
Yeah.
I have to then inquire, and you'd have to provide evidence to support that the ones that you're talking about. We got to know what they are. So you just can't say 22-04-89983 was false, because I don't know what that is. I don't even know the allegations behind it. So
This is what I said. This was loaded with that as well. The police report were because. Go ahead, listen.
And let me ask my clerk before. Ms. Clerk, did you receive any other evidence regarding this matter?
I am actually double checking right now to make sure. Ms. Wages, let me make sure. Did you send it in under any different email address, or would it have come from the same one where the other evidence came in from?
Came from the same evidence, with the same evidence.
Okay, I will try to pull it up again and see if I can find anything else.
All right, this is your second email. And this is the email. Can you see my screen, counsel, and Ms. Thomas-Way? Yes. Okay, so this is what you emailed the clerk. These are incident reports. Is this what you're referring to, these incident reports?
Yes.
Okay. All right, counsel, she's saying that these incident reports is what she's referring to. Are those being the false reports of crimes?
Your Honor, although I do understand what she's alleging, one, again, she went to jail and was adjudicated and pled guilty. And then two, all of these are from different dates other than even the alleged surrounding dates of the alleged incidents. So, we don't believe that this meets the statutory language, of a crime.
And just so I'm clear, I would like you to finish up the comment, because I want to see this evidence that you say confirms that she has pled to it. I think that's the thing, that if anything, but obviously we haven't gotten there yet. So Ms. Way, if you have any other questions for Ms. Way, we can proceed with those. Otherwise, we can conclude with the applicant's case in chief. Any other questions for Ms. Thomas-Way?
No, Your Honor.
All right, Ms. Way, anything else before we conclude with your case?
No.
All right. Counsel, this will now be obviously the respondent's opportunity to introduce any evidence as well as any testimony. I understand that you said that there was some evidence that was submitted to the court. What would you like the court to look at first?
Your Honor, I would like to look at let's do the adjudication.
Okay.
Let me bring this up. So also after the allegations, it says that I'm disabled. So if you can enable me.
Oh, you're disabled.
Yeah, if you can enable me to share the screen.
I'll be honest with you, counsel. We don't let anybody share the screen but the judge.
All right. If you look at
it tends to be safer that way, I promise.
It's okay. If you look at our Exhibit 5 first.
Exhibit 5. Okay, I had initially this guilty thing up here. Exhibit 5. Hotel. For someone who did not get the notice, you have well prepared, counsel. You got exhibits that they're numbered. For just getting a little bit of notice, you seem to know a little bit of what was going on. Hold tight for me to see which one is 5.
Pray for the best, prepare for the worst, Your Honor.
That is what good attorneys apparently do. All right, hold tight. Okay.
And first, we want to start to just say that this court has already adjudicated the matter. It basically heard another hearing to determine the merits of the case filed by Mr. Way. And in that hearing, the court determined that there was probable cause to issue a warrant. And then if you look at Exhibit 6, which goes into that evidence, you will see that she pled guilty to that on the merits. So
there was a criminal application warrant hearing that subsequently was heard in 2022 that resulted in a probable cause and a subsequent case that led to a guilty plea. Is that what you're telling me?
correct. And this guilty plea came in May of this year, 2023.
Now, it doesn't say here what specifically this, because the notice that you're identifying for the 29th, it doesn't say what the allegations were, right? For what
Right.
So
Right.
that does make it difficult for the court to say that this is exactly squarely the same matter.
No, I understand, Your Honor, but it's difficult for me to know which, if you look at Exhibit 4, though, you'll see that this originated from Exhibit 4 and it refers to the August date. Now,
I see.
yeah, and so it's the violation of the family violence order. So, Your Honor, again, our contention is that Mr. Way has not violated anything, but when we're talking in the general nature about what we don't know to prepare for, right, some random date, the only thing I can do is give the court previous hearings up until the day of her pleading guilty. So if she's talking about any other allegation, we can't defend anything that we don't know about. She can just pull any date. She can put July 25th. She can put December 25th. We don't know. The law is very specific that on this particular day, that this particular report was made to this particular police agency or government agency, and those facts were false, right? Now, if there's an issue, she says defects. Now, under Georgia law, there is a duty for everybody to report if there's even suspicion.
Well, hold up. You're getting in the argument of at the conclusion.
Okay.
So Miss Way, hold on. You had a question, Miss Way. Just want to make sure. You don't know if she's trying to object otherwise. Miss Way.
The case that he's talking about, they got dismissed because
Okay.
Mr. Way did not show up in court.
Listen, so
It got dismissed because Mr. Way didn't show up in court.
So
The issue that
Miss Way, Thomas Way, Miss Way. What the court's going to conclude, because I do think that I've heard quite a bit, and I do want to make sure that we're clear. This is the issue, Miss Way. Your current application does not give clear or not a definition of really what's going on. And so the court could be searching quite a bit, or the respondent could be searching quite a bit, trying to figure out exactly what allegation you're alleging is false. I myself am kind of confused too. And I've seen various incident reports, and you're saying various ones, and then I've seen guilty pleas here, and I've seen not. So the problem is have not been specific enough. I know you filed an application in May of this year that essentially says these are the ones that you're alleging that are false, but then you've got to be able to produce evidence to support that they are false. And I have to know what the specifics of that particular alleged crime was, so we can know the details and hear evidence about whether or not it's false. But unfortunately, in this situation, that has not been done. And I cannot let you try to figure it out and supply information as we go, because one, that is not going to give the respondent appropriate notice, right? It's kind of like catch you if you can, whichever one sticks, and that's not how this works, okay? So you haven't pled specifically enough, or at least identified in your facts and your evidence exactly what's going on for us to properly examine it. And that alone prevents me from being able to issue an arrest warrant, because I really can't ascertain what I'd be issuing one for. You understand? Now, let me be clear. Obviously, crimes are crimes. And if there's something more specific, obviously the court is not encouraging you to, but we're not saying that you cannot use the resources that are available to you as a citizen of DeKalb County. I'm just saying to you that currently we don't have enough specifics that have been alleged for myself nor counsel to be able to make an appropriate, one, for him to make a defense, and two, for me to accurately make a decision. You don't want me to make a decision on inaccurate information, because that doesn't benefit anybody. So what we're going to do this evening, I'm going to dismiss it. Now, whether or not that subsequently and you guys have something else that comes, we're happy to hear it. But as far as this evening is concerned, Ms. Way, we just don't have sufficient information. And I will say your connection is not that great. And so as we proceed, it hasn't been productive nor effective in trying to get us where we need to be. So we will not be issuing an arrest warrant. I do hope you guys get these things resolved, because obviously there are children involved. And truthfully, as they say, nobody wins when the family feuds. That is really, really a true statement. And so I hope you guys get it resolved. If there is currently a TPO issued, I'm glad we're doing this thing virtually. But I would really hope, for the kids' sake, that you guys can figure it out for both sides, honestly. But nonetheless, that's going to be my decision, and you folks are free to leave. All right. All right. Mr.
All right,
Kampelman,
thank you.
Ms. Price,
Thank you, Your
I
Honor.
do. I didn't hear you guys. Thank you, counsel. Thank you, Ms.
I do.
Ms. Kampelman.
I do.
Excellent. Excellent. All right. So, folks, we are here this evening due to the allegation of a criminal trespass that was taking place back on May 4th, 2023. And this has apparently occurred in DeKalb County. More specifically, well, I'll let you guys talk about it in the specifics here. But I just want to confirm, Ms. Maddox, you've emailed evidence. You also have several witnesses. And my understanding is that both of these particular respondents, comes from the same date in occurrence, correct? Same date of incident and occurrence, correct?
That's correct.
All right. So what we will do is get folks to do their opening statement. And because there are technically two respondents, they will have an opportunity each to say their particular piece, because they each have a case and they're each potentially facing arrest individually, right? Not just jointly. And so what I will do now, Ms. Maddox, is give you an opportunity to give a brief statement about this allegation and what happened. So it's about 7:40. I'll give you to about 7:43, 7:44 to tell us a little bit about the background.
Yes, sir. On December 19th, 2022, we executed an eviction of Barbara Kappelman and Joshua Price from my mother's home through the marshal's office, DeKalb County Marshal's office. In May, they broke back in. When we had the eviction done, we went in that day. My husband, who's one of the witnesses, and I, and along with some additional help, boarded up the windows from the inside, changed the locks on the doors to secure the house. And then, of course, most of my mother's belongings were removed to the yard. Barbara and Joshua have taken control of those possessions, although I do have an order from a Judge McNeil on September 1st, 2022, that said that we were to take possession. It actually says my uncle, but I had been substituted in as my uncle. My uncle, James Darden, was my mother's guardian while she was still alive. My mother passed away July of last year. But since that time, they have lived in the house illegally. After the eviction, they have brought other people into the house. We found, when we tried to go in and clean up the house before they broke back in, drug paraphernalia. So we know all kinds of things were going on in the house that were illegal in nature. Mr. Price seems to think that he can interpret the will. I am executor of my mother's will, and that's part of the evidence I submitted by oath of office where I was sworn in as executor. And he has denied me access to assets that belong to the estate. So in addition to breaking in, he also has taken, including an 1850 rifle, 1850 is in your 1850 rifle, that my father intended to be left to his grandson. Joshua Price has taken control of that as well. He seems to think he can interpret the will his way instead of the way that my parents had it written. The will does not say that they have a right to live in the house. It only says that the assets are to be divided between me and Barbara Kappelman. And I would like to have them removed from the house, this time for good.
Okay. Let me hear from Ms. Kappelman.
They're speaking to you, Do you have anything to say?
I took care of my parents and worked full time. They never came up.
I can't hear you, Ms. Kappelman. You're going to have to sit up and speak into the camera.
Come up and help out when my father was still alive. I worked full time and took care of both my parents full time. No one down there came up and helped me at all. When Daddy died, they came up and dumped the dumpster, took my mother for a couple of days and brought her back. They didn't help me do anything. I had to find people to help me take care of her in the house and clean it back up after they trashed our house and tore it apart. She never once came to the house and helped out at once. Not once. I had to cut back my hours, take care of her. She had dementia starting. She had a silent stroke. There's no reason why I should be. I am on the will. I have the signed will right here
The one by the judge.
by the judge that she signed when she was James was 3 years old.
Can I speak, Your Honor?
Well, hold on. I'm just waiting for Ms. Campbellman to
She
finish.
made up stuff to make it look.
Calm down. He gets a little emotional about this, sir.
Where
Okay.
was she? Where was everybody? Did my uncle backs out and leads to her?
Hold
I
on,
think
hold-
this is,
Calm down.
she shouldn't even be allowed to take care of this because too much is going on. We should have somebody else appointed to take care of the estates.
All right.
She-
Mr.
Really,
All right. All right, Ms. Campbellman.
Calm down.
Hold on. Do you have anything specific regarding the allegation of criminal trespass that you'd like to say?
I didn't even get to hear it because the internet went down.
Her, what she was saying is she doesn't feel she's trespassing in the house that she owns.
And people were breaking it.
Okay, well, hold on. Wait. Listen. I have to still do this in order to spite people's emotions. That doesn't give you the justification of just doing whatever. So, Ms. Campbellman, if you're finished, I'm going to give Mr. Price a statement opportunity to do it as a opening statement as well. It's 7:44. I'll give you about 3 to 4 minutes, sir. So go ahead.
I'm under the impression that Ms. Barbara Tupman owns the house. I was living there before the mother died. And in regards to what Ms. Mary said, her uncle only had rights under medical, is what the paperwork says. Legally, he was only allowed to make medical decisions. Okay. Barbara was living there prior to her mother's death, been there her whole life, which I've submitted the documents. And she has the signed will by the judge. So I have no reason not to believe. And then furthermore, the pictures I emailed about the eviction, her uncle renounced his role. In the same day he renounced his role, Mary paid for the eviction to have it illegally removed.
And throughout
And she's,
all my parents'
we
stuff,
didn't get this notice for this court date until this past Saturday and didn't have time to prepare. But every communication with her, I've recorded. Everything's been documented on our end. You know, if you look at some of the pictures that I've submitted, that's not how an eviction is handled. They broke the antiques. They broke, even Mary was crying about it. I got video of that because the house was wired for sound with cameras. You know, she was misled on the eviction as well by the DeKalb County Marshal. They destroyed our stuff, but she paid for that eviction the same day her uncle renounced his role of the will because he knows wrong than done. You know, she had all of our stuff put out and she didn't even put out all of our stuff. People were stealing what was in the yard, breaking stuff. For 4 days, I was at that house after they legally kicked us out. And I saved and salvaged stuff for 4 days in the rain by myself. Even the neighbors didn't even help to save their stuff and put it in storage. This is a civil matter, in my opinion, but I'm not the judge. But Barbara's been there for over 20 years and got documentation to prove it. You know, I've submitted her IDs, mail from through the years to show it. She's been on the deed 3 times. And that's on y'all's own public website.
Okay. All right. Are you guys?
If anything,
Is that
Mary is
it?
only trying to, she's called us, and the only thing she's interested in is a ledger from the father. The house is tied up in probate. Okay. You know, I've been maintaining it and remodeling. I've just painted the whole inside of the house. I was in the process right now of doing the flooring. And is it costing them anything? No.
Okay.
That's hurtful. We've been busting.
All
our
right.
butt
Now
now.
that's a hold tight. That's enough. So Miss Maddox,
Yes, sir.
we're going to get in your evidence here. Now I know you've got a lot of witnesses, and I just want to make sure that I've gathered here exactly what we're doing here, because you've got criminal trespass allegations back in May. Mr. Price was allegedly arrested that day, right? So that means they can't have a case against him. It's already been dealt with and adjudicated. You understand? So if from the date of the allegation that you're talking about, I've read the report. He was arrested that day. It says that he was lodged in DeKalb County Jail.
He was arrested for another matter and expedited to Gwinnett County for transferring a gun illegally. I suspect it was one of my father's guns.
I don't know. I just know that I'm looking at a police report that indicates that he was, from this incident, was arrested. He said specifically they observed 2 trespass forms posted on the window. How about they said, however, does not specify any names. Right?
That's because it had faded by that point, unfortunately.
No, it was never put there.
Hey, wait, listen. We're not talking while I'm talking.
Yes, sir. Sorry.
So I understand that he was wanted for arrest by Gwinnett County. And so he was arrested then. And so you're saying because he was arrested, but he wasn't arrested for criminal trespass. And so that's the reason why you want him now arrested for criminal trespass. Is that correct?
That's correct.
All right. And I just want to make sure that I understand. These criminal trespass warrants were issued and the police came, but you're saying that the police failed to arrest them because there was just a faded document?
Well, they show the will and nobody ever reads the will. The will doesn't say that Bart has a right to live in the house. The will says the assets will be divided. So, but they show the will and the police leave.
Hold on, folks. I don't, clerk, if you can give me access to mute people, I greatly appreciate it.
Judge, you have co-host permissions. I'm not sure why you're not able to do it on both screens.
I got it.
But I did it for you.
This is your sister. I did see the order for you to own the property because she didn't appear. I did see that. That wasn't necessary. I did see the will. You guys are entitled to your mother's assets 50-50. You just happened to, for some reason, court order because she didn't show. They gave you the authority and then you submitted an eviction, right? Is that correct?
The eviction was started by my uncle, who was mom's conservator, her guardian. And because she had to be removed from the house because of an accident that happened in the house. And they basically put my name in because it got caught up in COVID and was drug out, and my uncle was starting to have health issues.
So you got to, because I'm not, I understand your witnesses, but, and we can get to the criminal trespass. I've got a report here. So I'm just trying to understand the background here. There was a writ of possession that was issued, which I saw, right? And that writ of possession was, this was against Dr. James, conservator for Barbara Copeland and Joshua Lee Price. That was back in September of 2022. So we're now a year later, right?
Correct.
Okay. And you're saying that as a result of that writ of possession, they should have been evicted. And then as a result, they came back in and you want them arrested.
Correct.
And this has been multiple times that they've been in.
They moved in and stayed, and we've not been able to get them removed.
And tell me why you have not been able to get them removed.
They flashed the will to the police, and the police leave. Now, I should probably tell you, I live 3 hours away.
Mm-hmm. So who do you, and not that it matters, but I'm just curious, what is your intent with the property?
We want to clean it up and sell it, and proceeds will be split between us. That's what the will specifies, and that's what I intend to do as the executor. That's my responsibility. Right.
I mean, I saw the will. You don't get you don't get to take everything. Now,
okay. Josh states we gave permission. We did not give permission for him to do work on the house. We said the house needed to stay empty.
Okay. And when is the last time Okay, so you're saying they should have been arrested in May because they had been evicted in September and then moved back in.
The eviction actually took place in December.
Okay, because it took a minute for it to be executed. I understand. I understand. And then they were evicted.
They were evicted.
And then they want them. So you want your sister arrested to go to jail, and you want Joshua to go to jail as well. Is that correct?
Yes, I do.
Okay. All right. So who specifically? I'm looking at your evidence. So what will your witnesses testify to them being in the property? Is that what you mean?
Being in the property, having wild parties in the property, having drug deals come in and out of the property, having prostitutes come on the property, being up late at night, making loud noises, disturbing the neighborhood. They have a killer pit bull that scares the neighbors half to death because they have small children.
Let me ask you this question. Have you filed a writ of possession?
No, I have not.
And why not?
Because we weren't sure if a second one would be enforced since the first one hasn't been enforced.
Well, the first one was enforced because they were evicted.
But they came back, and when we called the marshal's office, they told us to call the police. We called the police, and the police haven't removed them.
Because it's a halfway civil matter. And I know it's not a full civil matter because they've been evicted once, and then there's the allegation of criminal trespass. But at the same time, but you're saying when they moved back in, they never had the authority, is what you're saying.
When they moved back in, they just moved back in and took over and were not removed.
Yeah, I understand. All right, well, you can bring out your first witness.
Okay. They are the neighbors, either Nicole Burton or Matt Jeffries.
Okay.
Actually, can I have Ricky Maddox, my husband, come first?
That's what you will have Ricky come in. I will tell you whoever is there will be cross-examined, whoever you allow to come in. So if we can bring in Mr. Maddox. All right, now, Miss Maddox, I'm going to let you ask your husband some questions. They need to be open-ended questions. You cannot ask direct examination. Cross-examination type questions, meaning that you need to say, what do you know? On this date, what did you see? You know, not like, isn't it true that, because that is more of a cross-examination type questions, right? And so I will allow you to do a direct exam of him. I'll give you about four minutes or so, 5 minutes. It doesn't need to be lengthy, and you can start now.
Ricky, please tell us what happened the day of the eviction.
Oh, we showed up at the Thornwood Drive residence, and the marshal's office showed up. We had you had hired people to remove the contents, and I had help there to assist. And we, after the eviction, we went in and changed the locks on the front door and secured the house by placing OSB board and plywood across the interior of all the windows on the lower level and windows on the second level that might be accessed from the garage roof. That's basically it.
And what happened on May 4th when we got the call from Josh and Barb?
They said that someone had removed the air conditioner under the carport and broken in the house. And you asked Barbara if she was in the house, and she said yes. And she said that they had removed the locks from the door, and we told them to put the locks back on. They were supposed to be, the locks were supposed to be replaced, and that they were not supposed to be in the house.
Tell us about our call to the police.
I think it was the next night or whatever. We had found out from the neighbors that they were still in the house, and so we called the police. And then we were first initially told that they had been removed from the house, and that they were not still in the house. And then when we went up to be sure the house was secure, we found that Josh had been removed for a warrant for some prior arrest or something unrelated to this, and that Barbara and the dog were still in the house, and we called the police again.
And what happened to that Sunday when we called the police again?
There was 2 police officers showed up, and they talked to Barbara on the telephone, and she came outside and she showed them a paper that supposedly was a copy of the will that we've been requesting since shortly after your mother's death, and she had not made available. But that's what we were told that it was, and we were not expecting to do any more than just secure the house. We did not know they were in the house, so we didn't have any paperwork with us, and so therefore the police wouldn't remove her at that time.
I just want to briefly interject. Has the probate court seen this will?
Yes, we had to probate from a copy, but we have a sworn affidavit from the attorney that prepared the will that it is the correct will.
So the probate court has already seen this will.
Yes, it's been probated. I've been sworn in as executor.
Okay. But before you were sworn as executor, did they see this will?
No.
Not the will Barbara has, but a copy that had been provided to your uncle by your parents.
And it's the exact same one?
It is.
I think with the exception of a clerical error, which the attorney explained to the satisfaction of the probate judge.
And that was before or after, Ms. Maddox, that you received the authority to have full rights to this property?
That was...
Because that order was signed September 1st, 2022.
The will was executed in, I think it was February, I believe.
When you say the will, that's not the will, but what are you saying?
Oh, no, the will. Now, the eviction was in December.
Mm-hmm.
The will was probated in, I believe it was February. May have been March, but I think it was February.
Of the year?
Of 2023, this year.
You can
We
finish.
had problems with, my uncle was conservator, couldn't get released, and we were caught up in paperwork in the court trying to get me named as executor. And I am specified in the will to be executor.
Has the probate court completed everything?
Yes, sir, they have.
And they have completed everything.
I have an employee identification number. I've set up the bank account and monitoring everything associated with it.
And I only, because this is important. Are there any pending issues or things, may not ask her, but by Ms. Campbellman, your sister?
None that I am aware of.
Well, yeah, you haven't been able to get the property. The property, and there's been no funds dispersed.
Yeah, there's been no funds dispersed. That's true. We have not been able to get access to the property on Thornwood Drive.
And so we can't sell it. We can't.
All right, I know you got a lot of witnesses, but I got a lot of questions. Hold on, Mr. Maddox. So the property that was put on the street, was that your mother's property?
Not all of it. Some of it was my mother's. Some of it belonged to my sister.
Was some of that property that was your mother's, she'd be also entitled to as well as you?
Some of it she would, but she's taken just about all of it.
I got it. Okay, continue with Mr. Maddox if you have any other questions for him. Any other questions for Mr. Maddox?
Ricky, also tell us about what happened when we tried to acquire the property for they have in the storage buildings that we paid for.
Well, they had moved the property after the eviction to 2 storage units, and they had and you had been paying the monthly storage fee, and Mr. Price and the management at the storage unit had run into some difference of opinions or whatever, and so they rather than to continue in business with him and the units in his name, they chose to evict him. They refunded 1 month's storage fees and chose to evict him. And they said that if he would put the units in your name, they wouldn't have to, foreclose on the unit. And he refused to do that. Initially, he had told us that he would sign it, but he didn't. And so they have, I guess, confiscated. Well, I don't know if it's the proper legal term, but anyway, they have confiscated the contents of the 2 storage units.
Also, would you also explain our situation, how far away we are, and kind of what led up to Mom not moving down here with us?
Well, she had made a decision after your father died to stay in Atlanta, and then she had signed a power of attorney previously with her brother, the James Darden, and after she wound up in the hospital from some injuries to the head, he stepped in, and he had been advised by the patient representative from the hospital and the elder care representative from DeKalb County that she was not to go back to that house. They had also had some prior charges against Miss Kappelman for elder abuse, and I understand that was later converted to disorderly conduct charges, and which she pled out. And but anyway, that resulted in her being moved to a rehab facility in Eastman for a short period of time, and then he chose to transfer her to a nursing facility here in Cochran. But that was done he made those decisions based on the advice from the patient representative at Northside Hospital, and also a DFACS elder advocate in DeKalb County.
Okay. All right. Now, I know you guys, any other questions specifically about the event that we're talking about here in May?
No, I think that's pretty much
Okay.
all right now.
All right. So now, Mr. Maddox, I'm going to give Miss Kappelman or Mr. Price an opportunity to cross-examine if it's necessary. Mr. Price, do you have any questions for Mr. Maddox? You're on mute, though, so I can't hear anything you're saying. You need to unmute.
During this time frame, we were kicked out December 19th.
Wait. You got to have questions for Mr. Maddox. Do you have any questions for him? If you have no questions, it's fine.
Yes, I do have questions. Have y'all
For
had
Mr. Maddox?
Yes, for Mr. Maddox. Have y'all had a proper reading of the will and
One question
the
at a time.
definitions of the legal word? The question is, have y'all had a legal reading, and what part does he play in this? He is not in the paperwork.
I was not present at the reading of the will, but yes, it was.
Hold on, don't talk over him, Mr. Price. Continue, Mr. Maddox.
It was read, and my wife was present, and her aunt and uncle was present, James Darden and Pat Darden, and I think Barbara's son, James Kappelman, was present by Zoom.
Any other questions for him?
Ricky, how many times did I call you to try to get y'all to come to the storage unit to get y'all stuff? I've been very diplomatic about this to save Mary Maddox and Miss Kappelman's family, the Nutting family's property. Who's helped me do this? How the stuff get to the storage? Who did it? Because when y'all wrongly kicked us out,
So hold on, it's got to be a question. You're not testifying. So do you have any other questions for Mr. Maddox, or we can conclude then?
Yes. What stuff did you take off the property during that eviction? I want that on record.
I don't
Because I got the
remember.
video of it.
Oh, wait,
Let
let him talk.
There was nothing removed the day of the eviction
Hold on, man.
because
he's purging.
Mr. Price, you don't have to tell me that he's perjuring himself. Let him finish talking.
the day of the eviction, there was nothing removed because the advice of the marshal's office was that she had to be given 24 hours to remove any of her personal property, and it would be the next day before anything could be removed.
Okay. Any other questions, Mr. Price? Last question for Mr. Maddox.
It's really not involved in me, but I've been the one saving their property and remodeling their house and supplying everything for free. And
Do you have a question?
they did us wrong.
Do you have a question,
No, sir. I already
don't have any more questions.
got what I needed. I got what I needed. He just said what he said when I got video proof that he's lying.
Miss Kappelman, do you have any questions for Mr. Maddox?
They took weaponry off that property that very same day.
There's no other questions.
Why
Miss
was
Matt,
my birth certificate, my license in the trash can, along with James's
Hold
airline?
on. The administrator of that will is held
wait,
responsible.
no,
for
Mr. Price,
any
Mr. Price,
incurred.
Mr. Price, your question time is over.
Dude, they stole my stuff. They didn't look at the pictures. They didn't even put it all out. That was illegally handled. And
All right. Okay. So again, folks, we're trying to have an organized and orderly presentation of evidence. We can't talk over people. We're on Zoom. It makes it really difficult. Miss Mary Maddox, do you have any other questions for Mr. Maddox? So I can let him.
No more questions for Mr. Maddox, sir, Your Honor.
Okay. I'm going to be honest with you, folks. I'm hearing the evidence, and more I'm hearing it. I have more and more questions, Miss Maddox, as well as Mr. Campbellman and Mr. Price. Miss Maddox, tell me, do you know when they moved back in or went back into the property?
They called us on May 4th, 2023, and they said they were in the house. Since they didn't have access with a key, we know they broke in.
So they told you they were in the house.
They told us they were in the house. We said, you need to leave the house. They did not.
Okay, and so they had been out the house since December and then returned some months later, is what you're understanding.
That's correct.
What will your other witnesses testify to?
Most likely to the fact that they are in the house and the difficulties they have created in the neighborhood.
All right. I will tell you, we don't necessarily need to hear about the difficulties. We really need to hear about the criminal trespass. Let me figure this out. Mr. Price, can you unmute for me?
say again, sir?
Are you in the subject property that you were previously evicted from?
We went back to that property because every homeless person in town was robbing the family house, and the air conditioner was already pressed in and an entry was made. They were starting to strip the electricity, the wires from the house. So yes, with her being Barbara being half owner, not the liquid assets to be separate, but the actual house is not to be sold, and that is stated in the will. I got a witness here too.
So
file these papers for us.
Okay.
That's, you know.
I got it. So folks, hold tight.
Yes, sir. They just don't like me.
I got it.
They push their sister around, and they intend.
And I don't mean to mute you, but what I want to be able to really address, folks, is that you guys have a serious family issue that's bullied over here in the criminal court. That's the serious concern. In truth, I know it's been some time since they were initially evicted and then they came into the subject property. Whether or not that rises to the level of another need for a civil matter or another need for the criminal warrant, for the criminal trespass is something to be considered and decided, because though you're saying they had no rights, they subsequently they left and then they came back apparently months later. Obviously that was after this order or the probate was being completed and you were identified as executive. But this is my bigger issue. And this is what makes me a little bit hesitant here, because Ms. Maddox, you have the responsibility, I guess, of being the executor and subsequently trying to, I guess, do best with the assets that your mother has left. You're finding it in your best interest that your sister living at this subject property is not the best interest of the estate. And as a result, you sought to evict her, which would very well be your right as executor, right? The issue that I'm finding, though, is that you guys are both have a joint interest in the same subject property that you've evicted her from, which she has right, I guess, to the value of, but maybe not possession of, is what you're saying, of the property. And so you're saying you can't live there, but you can get paid. We don't know what that amount is because you don't know what the value of the house is because you haven't sold it. My other concern, though, is when this initial, and I'm not trying to rehash issues, but I just think it's interesting that property that was of your mother's that would be of the estate was subsequently evicted and put on the street, that you would also have interest in, and the estate would have an interest in maintaining and selling, which becomes an issue as well. Because there would actually be some concern about, obviously, those properties, if not damaged or lost to you as well, Miss Maddox, as well as your sister. And so then it then becomes about possession. And then you're saying she should be arrested being in possession of the subject property, which she has a equitable interest in, but she doesn't have a possessory interest in. And what does that all lead me to say? What does that all lead me to say? Well, one, it leads me to say that I'm frustrated because I see two family members that obviously are not getting along and obviously have the same interest in the same property. It just so happens that the court awarded you, Miss Matt, for good reason or bad reason, the authority over the property. Whether or not I'm in position to accurately say that this is a full criminal trespass without everything else being taken in consideration, I can't do. I can't say this criminal trespass and ignore the fact that she's got an equitable interest in the property. Ignore the fact that as well, everything else is going on. I'm not saying, Miss Maddox, that she subjectively has a right to stay there, but I don't know, because of the distance that has happened when she moved and now that she's moved back in, whether or not it would be your responsibility as well to have her evicted. These are common issues that come up. And otherwise, I'm just going to tell you, criminal trespass is only going to remove the people. It does not do the same as an eviction where the officers come and remove everything out of the property, which is usually one of the reasons why officers do not remove people from properties in these situations, because there is not, people become tenants or tenants at sufferance or possessory, squatters, but they still have rights, right? They just can't be immediately removed without certain other processes, particularly because they were already evicted, but that was evicted a long time ago. So it wasn't like they were evicted and they came back on the property 2 days later. This was 5 months plus later. And then in conjunction with everything else that's going on, I am going to hold off on issuing arrest warrants this evening. I don't know, because again, you have a lot of other property to divvy up and things to do. And that seems to have just been granted earlier this year. I'm not going to make any determination on the estate issues because you have a probate issue. And I would maybe suggest that you take that up specifically with the probate court. I don't know if this is the appropriate forum so that the probate court can be able to appropriately address the fact that she's in there, but she also has an interest in everything that's there. And I'm also concerned because you got your rights. I'm not going to get into that because I think that becomes a probate issue and I don't want to get into that. But what I do have, I have people who are backing a property that makes me believe that this may be more appropriate or a civil matter before it comes to me for a criminal adjudication. And so because of that, I'm not going to issue an arrest warrant this evening. Now, Ms. Maddox, that does not mean that you do not have the rights to evict these people. It does not mean that you don't have a right to call officers. But again, as far as all of the evidence that has been presented to me this evening, I don't have enough clear evidence of all that's going on to say confidently that them being arrested for criminal trespass is the appropriate decision. And so that's not what I'm going to do. You can take it up with the probate court or the civil matter. But as far as this criminal warrant application hearing is concerned, I'm not going to grant that this evening because I don't meet with the totality of the evidence meets probable cause. And that's going to be the court's order. But let me clear it up with Miss Maddox, the sister, Miss Campbellman. Let me be very clear. You're not the executive. You do not have the right to prevent your sister from selling this property. She's got the right to do that as a matter of what this document says. You being in possession of the property at this current moment, I can't say specifically if it's criminal or civil because of all of the issues that have been taking place. But with all that being said, I always remind people, you can be arrested for making waste. And so in the event that you destroy this property, you could have a serious consequence against you beyond arrest. And so I will state that, and that will be my conclusion to this particular matter. I really do hope and pray that you guys get it resolved, because honestly, family issues are really best settled between the family. But if they can't be, I am happy to send people to jail, but that's not what I will be doing this evening. And that will be the order of the court, okay? And so you guys are free to go. If you have any questions, you guys may lodge those in a letter to the court, okay?
Thank you, Your Honor.
Thank you.